Hello everyone, welcome to the Module 3 of the course, which deals with the legal requirements and labeling rules related to food allergens. We'll start by having a look at the European legislation with some consideration. In recent decades, alongside the growing attention to aspects of proper nutrition, interest in food allergen and intolerances has increased equally. All in all, recently discovered, the topic of allergens and intolerances is also destined to increase its relevance, also due to increasingly individualized diets and emerging food compatibility, as made visible by the nutrigenomics that will lead to the inclusion or exclusion of certain foods based on individual profile. Since there is no cure for food allergy, the only way to manage the condition is to avoid foods that make the person ill. This can be achieved by checking ingredient details on labels of pre-packed foods and being provided allergen ingredient information for non-pre-packed ones. Therefore, it is very important that food businesses provide clear and accurate information about allergenic ingredients in their products, and it is important that these aspects are regulated by a specific legislation. Indeed, in order to regulate the information about allergen on foods, EU Regulation number 1169 of 2011, the so-called Fitch Regulation, introduced new rules for food businesses related to the labeling and provision of allergen information. The EU Regulation on Food Allergens provides in particular clearer and harmonized presentation of allergens for different types of foods, not only pre-packed ones, but also non-pre-packed foods, including in restaurants and cafes, and the same labeling requirement for online, distance selling or buying in a shop. This regulation entered into application on the 13th of December 2014, but obligation to provide nutrition information applies since the 13th of December 2016. The regulation clarifies the responsibilities of food business operators with respect to food information. This means that food businesses operator must provide allergen information to the consumer for both pre-packed and non-pre-packed foods and drinks, but also handle and manage food allergens effectively during food preparation. Moreover, food businesses must make sure that their staff receive proper training on allergens. This regulation entered into force on the 20th day following its publication in the Official Journal of the European Union, the 13th of December 2014. However, when Food Information Law established the new requirements, a transitional period after the entry into force of the new requirement was granted, except in duly justified cases. The provision of nutrition information became mandatory for most foods on the 13th of December 2016. During the transitional period, foods bearing labels not complying with the new requirement could be placed on the market, and stocks of such foods that were placed on the market before the end of the transitional period were allowed to be sold until exhausted. Fundamental objective of the regulation is to ensure a high level of consumer protection. This is obtained by rules aimed at creating the condition to be able to make adequate and conscious choices in one's own interest, not only from an economic point of view, but also health, environmental, social, and ethical. Moreover, the regulation aims at guaranteeing the principle of the free circulation of safe and wholesome food, thus the general interest of the internal market. In order to provide an immediate and practical background to the topic of food allergens, it can be stated that food producers have an obligation to provide safe foods, as stated in the Article 14 of the Regulation number 178 of 2002, the General Food Law. The European Union has regulated the issue of information to consumers about allergens and similar substances in an increasingly harmonized way. The advent of Regulation number 1169/2001, Food Information to Consumers, then made standard a series of communications to be given to consumers and patrons, in the case of restaurants, taverns, farm holidays, in general administration. The preparation of a regulation, however, although directly applicable, does not exclude diversified forms of information to consumers under the aegis of the health ministers of the member states of the Union. In addition to regulatory aspects, in the EU, there is a centralized assessment of the risk posed by allergen within the activity of the EFSA NDS panel. It is also noted that the European Commission will be able to adopt, through delegate acts, rules to expand this list of allergens on the basis of the progress of knowledge. Allergens are a risk to be reported to consumers and to be monitored through a corporate self-control plan. Now, let's move to consider the European standards and norms on food products. In 2002, the European Parliament and the Council adopted Regulation 178/2002, laying down the general principle and requirements of food law, General Food Law Regulation. The General Food Law Regulation is the foundation of food and feed law. It sets out an overreaching and coherent framework for the development of food and feed legislation, both at Union and national levels. To this end, it lays down general principles, requirements, and procedures that underpin decision-making in matters of foods and feed safety, covering all the stages of food and feed production and distribution. It also sets up an independent agency responsible for scientific advice and support, the European Food Safety Authority, EFSA. Moreover, it creates the main procedures and tools for the management of the emergency and crisis, as well as a rapid alert system for food and feed. The General Food Law Regulation ensures a high level of protection of human life and consumers' interest in relation to food, while ensuring the effective functioning of the internal market. The list of the 14 major allergens is specified in the Annex 2 of the FITS regulation as substances or products causing allergies or intolerances that need, therefore, to be labeled on food when used as ingredients. This list contains the correct naming of all 14 allergens, as well as the allergen letter code as recommended by the Codex Commission. Specifically, A, cereals containing gluten, B, crustaceans such as prawn, crabs, and lobsters, C, eggs, D, fish, E, peanuts, F, soybean, G, milk, including lactose, H, nuts such as almonds, hazelnuts, walnuts, L, celery, M, mustard, N, sesame seeds, O, sulfur dioxide and sulfites, P, lupin, R, mollusks such as mussels and oysters. It is important to highlight that the obligation is not only related to ingredients of food products, but this also applies to additives, processing aids, and any other substances which can be present in the final product. An important aspect of the regulation is that allergen labeling must be provided in written form. Therefore, hospitality establishment must provide written information at one of those points. The point of presentation, for example, with a chalkboard or a menu, the point of sales, for example, the cafe counter, or the point of supply, for example, a buffet table. If guests are being explicitly told, verbally or in writing, the allergen information is available, a written information sheet or booklet with a complete allergen information must then be provided to the guests. Simply indicating verbally which dishes contain allergen is no longer a satisfactory measure. However, depending on how the food is provided to consumer, different allergen labeling rules can apply. The Article 9 of the FITS regulation indicates, among mandatory food information, the list of ingredients that shall be preceded by a heading that includes the word ingredients and must include all the ingredients of the food in descending order of weight and designated by their legal name, and also any ingredient or processed aids listed in Annex 2 or derived from a substance or product listed in Annex 2 causing allergies or intolerances used in the manufacture or preparation of foods and still present in the finished product, even if in an altered form. In the absence of a list of ingredients, the indication shall comprise the word contains followed by the name of the substance or product as listed in Annex 2. The indication of the particular refers in the point C of Article 9 shall not be required in case where the name of the food clearly refers to the substance of the product concerned. According to Article 21 of the Regulation 1169/2011, labeling of certain substances or product causing allergies or intolerances, allergens shall be indicated in the list of ingredients with a clear reference to the name of the substance or product as listed in Annex 2. The name of the substance or product as listed in Annex 2 shall be emphasized through a typeset that clearly distinguishes it from the rest of the list of the ingredient, for example, by means of different font, style, or background color, bold, contrasting color, or by underlining them. In order to ensure better information for consumers and to take account of the most recent scientific progress and technical knowledge, the Commission shall systematically re-examine and, when necessary, update this list in the Annex 2 by means of delegate acts. In the case of pre-packed foods, mandatory food information shall appear directly on the package or on the label attached. Pre-packed food must have an ingredient list. Therefore, allergenic ingredients must be emphasized in some way every time they appear in the ingredient list. Allergenic ingredients must be declared with a clear reference to the allergen to ensure clear and uniform understanding. Examples of ingredients that need to be clearly referenced to the allergen are tofu, when the relative allergen is soy, tahini paste for sesame, whey for milk. Allergen advice statements can also be used on the product label to explain how allergen information is presented on a label. For example, allergen advice for allergens, see ingredients in bold as reported in the label in the slide. All allergen advice for allergen including cereals that contain gluten, see ingredients in red. Alcoholic beverages that contain more than 1.2% by volume of alcohol are exempted from the mandatory listing of ingredients and nutrition declaration. While an allergy to alcohol is rare, an allergy or intolerance to ingredients used to make wine, beer, or distilled spirits can occur more frequently. These include grains like wheat, barley, or rye used to make beer, which can affect people with celiac disease, non-celiac gluten sensitivity, and with allergies. Therefore, for alcoholic drinks with no ingredient list, allergens can be indicated by the word contains followed by the name of the allergen. Beside mandatory information, there are also a set of voluntary information that the food business operator can add to the labeling under his responsibility. Indeed, despite the most serious effort to manage allergens during manufacturing and other operations, in some cases the unintended presence of a small amount of allergens, which can pose a risk to susceptible individuals, cannot be avoided. As one of the measures to mitigate and manage this risk, precautionary allergen labeling was introduced. Also called advisory labeling, it refers to the voluntary labeling to indicate that one or more regulated allergens could be unintentionally but unavoidably present in a product and thus pose a risk to susceptible consumers. If there is a risk of a food product being affected by allergen cross-contamination, the label should include one of the following statements: might contain X, not suitable for someone with X allergy. Precautionary allergen labeling should only be used after a thorough risk assessment. It should only be used if the risk of allergen cross-contamination is real and cannot be removed. Prepacked direct sale, also known as PPDS products, are foods that have been packed on the same premises from which they are being sold. This might be for convenience, such as less mess handling food, hygiene reasons, or to maintain qualities. Food prepackaged in this way can look identical to food that is prepacked in a production facility for the final consumer. Food prepacked for direct sale are treated in the same way as non-prepacked food in the EU FITch labeling provisions. Consumers expect prepacked food to be labeled with any allergens. Therefore, when they select PPDS foods which have been prepacked on site, they could assume that as there are no allergens declared on the label, that the food does not have any allergenic ingredients. Therefore, allergens should be reported in each single pack. Prepacked for direct sale foods can include the following: sandwiches, bakery products, packed on site before a consumer selects or orders them. Fast food packed before it is ordered, such as a burger under a hot lamp where the food cannot be altered without opening the packaging. Products which are pre-packed on site ready for sale, such as pizza, rotisserie chicken, salads, pasta pots. Burger and sausages pre-packaged by a butcher on the premises ready for sale to consumers. Samples of cookies given to consumers for free which were packed on site. Food packaged and then sold elsewhere by the same operator at a market stall or a mobile site. PPDS foods provided in schools, care homes or hospitals and other similar settings will also require labeling. With the implementation of EU Regulation 1169/2011, labeling of allergenic ingredients has been extended also to non-prepacked foods. Non-prepacked loose foods are foods offered for sale to the final consumer or to a mass caterer without any prepackaging, such as meals served in a restaurant or a cafe. Member States remain competent to adopt national provision on the means through which allergen information is to be made available on such foods. In principle, all means of communication as regards the provision of allergen information are allowed to enable the consumer to make an informed choice. For example, a label or other accompanying material, or any other means including modern technology tools, for example, food menus, chalkboards, food order tickets, food label, or web pages, or verbal communication, so, for example, verifiable oral information. Regards should be taken to these national rules which might also refer to precautionary allergen labeling. It should be noted that precautionary allergen labeling for non-prepacked food would in most cases require consideration of other factors, for example the handling environment, which would require development of further guidance. In the absence of those national measures, the provision of the regulation concerning prepacked food are applicable also to non-prepacked food. Accordingly, in accordance with Article 13 of the regulation, the information about allergen must be easily visible, clearly legible, and, where appropriate, indelible and provided in a written form. Therefore, it is not possible to provide allergen information only upon request by the consumer. Special rules are related to the so-called free-from claims. Free-from foods are special ranges of food made without allergens. If a label states that a product is free from milk or peanut-free, it has to be based on specific and rigorous controls. These controls need to ensure that the final product is completely free of the particular allergen. This includes checking that all ingredients and packing material do not contain this allergen and that cross-contamination from other foods made on site is prevented. There is one exception to this rule, which is gluten. Gluten-free label products can contain a maximum of 20 milligrams per kilogram of gluten. The gluten-free label can be accompanied by the claim suitable for celiacs or specifically formulated for celiacs. If the process cannot be guaranteed or controlled sufficiently, it's possible to consider more factual statements, such as no gluten containing ingredients, also known as NGCI. However, other indications, such as low gluten content, reduced gluten content, and similar, are not allowed. Vegan diets exclude completely the presence of ingredients of animal origin, such as meat, fish, eggs, or dairy. Since the vegan label has not been yet defined by the legislation, it is based mainly on voluntary food information. Such information, however, should not mislead the consumer, not be ambiguous or confusing for the consumer, and be based on the relevant scientific data. To date, there are a number of national initiatives and voluntary certification schemes. However, the plethora of terms such as vegetarian, cruelty-free, organic, and the meat-sounding phenomenon indicate the need of a normative intervention from EU legislators to define the perimeter in which a food can be declared vegan. With regard to allergens, it is important to remember that customers sometimes can assume that vegan meals are free from animal-based allergens, such as egg, fish, crustacean, mollusk, or milk. This is not always the case, as low-level cross-contamination from these ingredients can occur during the production processes. Therefore, the cross-contamination possibilities should be carefully considered and declared in the food label. Many products require CE marking before they can be sold in the EU. CE marking indicates that a product has been assessed by the manufacturer and deemed to meet EU safety, health, and environmental protection requirements. It is required for products manufactured anywhere in the world that are marketed in the EU. In food or beverages, if food or beverages are meant to be sold in the EU, essential information must be provided so that the end customer can make an informed decision on their purchase. This information, therefore, must be accurate, easy to see and understand, not misleading, indelible. All food sold in EU must comply with Regulation 1169/2011 on the provision of food information to customers. The EU regulation also states how allergen information has to be provided to consumers depending on the type of food business. Food businesses must provide allergen information in writing if they sell or provide food to customers directly. This could be either full allergen information on the menu, chalkboard, or an information pack, or a written notice placed in a clearly visible position explaining how your customer can obtain this information. When allergen information is provided as part of a conversation with a customer, this can be backed up by written information. This would ensure that it is accurate and consistent. It is possible to display an allergy and intolerance sign to tell customers how they can find allergy information. If food is offered in the form of a buffet, allergen information needs to be provided for each food item separately and not for the buffet as a whole. This information can be provided by labeling the allergen contained in individual dishes or by displaying a sign directing customers to ask staff for allergen information. This information must be visible, clearly legible, and easily accessible to the customer. If food is sold online or by phone through distance selling, such as for food delivery or takeaway, allergen information must be provided at 2 stages in the order process. Allergen information must be provided before the purchase of the food is completed. This can be in writing, on a website, catalog, or a menu, or orally by phone. When the food is delivered, this can be in writing, allergen stickers or food or an enclosed copy of a menu, or orally by phone. Allergy information should be available to a customer in written form at a point between a customer placing the order and taking delivery of it. Takeaway meals should be labeled clearly so customers know which dishes are suitable for those with an allergy. It becomes essential for companies that produce, sell, and transform, as well as supply food, to be able to demonstrate that they are following good hygiene practices aimed at limiting accidental and unwanted contamination with allergen-similar substances. These good hygiene practices, however, are based on the same principle of self-control of the HACCP and integrated. It is recommended that businesses develop an internal allergen flowchart or an allergen map, considering which allergens are present on site, at which stage of the process they get into contact with other foods, how they are stored, and how they are indicated on the labels, and a self-control plan for allergens to be systematically reviewed and every time new ingredients enter the company. Food business operators need to make sure that they know what is in the food provided. This can be achieved by recording allergen ingredient information in a written format. Allergen ingredient information should be recorded on product specification sheets, included on ingredient labels, and ingredient should be kept in the original or labeled containers, included in recipe or explanation of the dishes provided. It's important to consider the impact when recipe change and up to date. It is important for food businesses to take steps to avoid cross-contamination in food preparation to protect consumers with a food allergy. There are a number of actions to take to prevent cross-contamination with allergens. These include cleaning utensils before each usage, especially if they were used to prepare meals containing allergens, washing hands thoroughly between preparing dishes with and without certain allergens, storing ingredients and prepare foods separately in closed and labeled containers, keeping ingredients that contain allergens separate from other ingredients. The sources of cross-contamination are many, and they all need to be carefully considered. Allergen cross-contamination can also happen through using the same cooking oil. For example, to cook gluten-free chips is not possible to use the same oil which has been used previously, for example, for frying buttered fish. If cross-contamination cannot be avoided in food preparation, customers should be informed that it is not possible to provide an allergen-free dish. With regard to the enforcement of this regulation, the food business operators responsible for the food information shall be the operator under whose name or business name the food is marketed, or, if that operator is not established in the European Union, the importer into the Union market. Apart from the possibility of making a customer seriously ill, food business operator could also face the risk of financial and reputational damage to the food business if failing to comply with allergen information requirements. Depending on local arrangements, local authority enforce allergen information regulation, checking and monitoring to see if food businesses are providing the correct information. For example, allergen information being given orally and/or in writing to consumers. The local authority and food business should work together in ensuring compliance. In most instances, this might involve a step-by-step approach. In some cases, if a food business operator fails to act on advice given by the local authority, an improvement or penalty notice might be issued. These notices formally outline the corrective steps that the business should take within a set period of time. Failure to comply can result in action from the local authority. A business can appeal against these notices in a specific time frame, depending on local regulation. If the requirements of this notice are not met, a penalty will be issued. In some cases, businesses might also face prosecution. Sanctions and penalties are defined by national legislation. Therefore, differences can apply in different EU countries. The specific situation in Italy will be considered as an example. On the 9th of May 2018, the Legislative Decree 231/2017, which adapts the national legislation to the discipline of the EU Regulation number 1169/2011 and established the related sanction, has come into effect. The penalty introduced are of an administrative pecuniary nature, but unlike the original prediction dating back to the preliminary examination of the decree, almost every provision sanctioned provides in the opening word the safeguard clause unless the fact constitutes a crime. This clause reserved the preferential application of the criminal sanction over the administrative one, if the specific conduct considered therein integrates the details of a crime. According to the Italian decree, sanctions relating to the violation of the disclosure obligation vary from 1,000 to 8,000 euro for the violation of the provision of Article 19 of the legislative decree, from 3,000 to 24,000 euros for omitting the indication of allergens present in the product sold or administered, from 1,000 to 8,000 euro for those who make the indication in ways different from those provided, a penalty that is likely to be halved from 500 to 4,000 euro if the violation concerns only formal aspects, from 500 to 4,000 euro for the food business operator who omits the mandatory information in the stages prior to sale to the consumer or the community. However, there are also reduction of penalties envisaged in specific cases. For example, a reduction of up to 1/3 of the administrative sanction for micro enterprises. The possibility of a reduced penalty, a lower amount between double the minimum or 1/3 of the maximum, if the payment is made within 60 days of the immediate dispute or notification of the same, and if the payment is made within 5 days from the notification, there must be a further reduction of 30% of the amount. Moreover, the institution of the so-called warning defined in Article 1, Paragraph 3 of the Legislative Decree 91/2014, or penalty notice, consisting in the possibility, in the event of remediable violation, that the supervision body, which for the first time ascertains the violation, warns the interest party to comply with the violated prescription by term of 20 days and proceeding with a formal complaint only in case of non-compliance.